All right, everyone, if you could please find your seats. We're going to pick up with part 2 of Building the Future We Want. As you'll notice, the moderator has changed. Moderating the second part of the panel, we have Professor Cristelia Garcia, who is the director of the Content Initiative here at Silicon Flatirons and one of our law professors. So, thank you.
Thank you, Connor. Good morning, everyone. Thank you for coming back for our part 2 of our conference. I needn't reintroduce our esteemed panelists, so we will pick up in the short time that we have here today and solve all the problems we've been talking about in the last couple of days, so we better be quick. I was telling some of the panelists and chatting with some of the organizers, I think for me as an intellectual property professor that does not focus dominantly on tech and privacy issues, I feel like as I've been sitting here the last few days, and I generally feel like this as I read through a lot of my colleagues' work, a lot of these conflicts that we've been discussing from the pessimism angle here, things like, we'll talk about in a moment, accountability, privacy, value divergence, they seem to me to come largely down to problems with us. Yes, to say that they're problems with people and not necessarily problems with technology, at the risk of using the, guns don't shoot people, people shoot people phrasing. That resonates from someone who's a little more on the outside of this debate than others. And so I want to start with these, what I'm identifying as these 3 big recurring issues and themes that have come up all weekend. To ask whether among these things, accountability, privacy, and value divergence, what do we do with these in terms of prioritizing them? And to the extent that this is a human problem, if you will, or a human conflict, do we have winners and losers in this? And how do we pick who is whom, right? So it's one thing to say, well, what we really need to do here is have the technology reflect our values. It's a whole other thing to define what those values are. And that is why, of course, we're being facetious when we say we're now going to give you the solutions in this panel. But I do think that we can spend some time having some meaningful discussions around not even asking, like, what do our values look like, but how do we even go about deciding what those would look like, and how do we accommodate divergence in views on these really key issues when we're talking about how we're going to address them. So I'll start with Liesl. I want to talk with you about privacy specifically. How do you see in the realm of all the issues that have been brought up about technology this weekend, where do you place privacy in the priority list, and do you see it as more of a short-term or a long-term issue?
Privacy has a good deal to do with much of what we've talked about, certainly not everything that we've talked about. The kind of emerging field of data protection, which started out as a subcategory of privacy, I think has evolved to mean something a little bit more. The privacy of your personal data, but then also how that personal data is used, specifically if it's used to try and for some of the forms of online manipulation that we spoke about yesterday in the debate, if it's used in ways that discriminate against people. And so, a federal baseline privacy law, which sets the standard for all parties that collect and use personal data, would certainly bring us much forward. It's one part of the conversation, but it's an important part of the conversation. It would help us avoid a fragmented situation in which multiple states are coming up with divergent privacy regimes. It would help us internationally, where in the European Union, they have created a model that they're very eager to export, and they're also eager to establish a model in which cross-border data flows are restricted unless the receiving countries have an adequate level of privacy protection, or unless the recipients kind of jump through some hoops and establish accountability mechanisms. Those accountability mechanisms are effective. I think AT&T and industry support accountability mechanisms, but a kind of more, a better long-term solution in which you don't have to negotiate a privacy shield with every different country that adopts that kind of regime, and which smaller and medium-sized companies can have access to those standard contractual clauses or mechanisms for transferring data would be ideal. So
great. Thank you. And Chris, if I can jump to you, what does this, if you agree with Liesl that a good first start would be to start with a federal program as opposed to having a sort of piecemeal state approach and something internationally that can help us so we are not engaging in one-off privacy shield negotiations with individual partners, what does that look like to you? Who's at the table deciding what goes into this federal regulation? And when we reach the point where we have divergent views, some people who are looking at the trade-offs, right? So anonymity versus information, personalization versus privacy. Who wins and who loses there?
Right. I mean, yes, first of all, very supportive of a comprehensive federal privacy bill. Supportive of efforts at the state level as well, honestly. We've seen great ideas and innovation coming up from the state level as well. But to protect everyone, a federal bill is probably the most effective way, which is why I think a lot of us are working on that right now. I think there are other priorities beyond privacy and other values to protect beyond privacy. I think privacy is a baseline one, and but we've talked about the importance of access and openness of technology. I think that's one. I think another that's urgent is the choices that consumers have in the marketplace, and that really comes down to the competition that we see among companies, the ability for rivals to rise up against dominant tech companies, and how do we foster that so that there are choices for consumers. And I think that there can be work done to create rules and protections for competition that can benefit consumers and give them choices. So, when you talk about you said anonymity versus information. I think anonymity is something that technology users have valued online, and yet there are harms that come with it. If there are choices in the marketplace for consumers on which platforms they can use, then they can make those choices based on how those platforms choose to manage them. I think that's the most ideal situation with protections that promote that sort of competition.
So you would see a way of handling value divergence, as I'm euphemistically calling it, to be having more choice in the marketplace so that consumers can sort into the platform that reflects
ideally,
their
but yes,
value
but
set.
that looks different. As I was saying in the first panel, I believe that looks different with different types of platforms,
Right.
and that the way that one platform can edge out competitors in search looks different than it does in the marketplace, which looks different than it does in traditional broadband ISPs, where they tend towards natural monopoly.
Right. And John, do you think that that's realistic? Do you think that consumers in the market are able to evaluate the platforms and understand what exactly that platform is providing them in terms of accountability and privacy protection, anonymity, if that's something that they want, that sort of thing? Is that, at this point, something that consumers can do?
So I don't think it's limited to platforms. I don't think that consumers have a great ability to assess or make choices about data practices about companies across the board.
Right.
And that's a real challenge. Now, the truth is that consumers make lots of choices about a lot of different products, digital products, non-digital products, et cetera, with incomplete information. And the question for government and the question for regulation is, when does that information, that incomplete information, rise to a point where it's harming consumers when they have an inability to do it? You look at food safety rules. There are some circumstances in which the government simply says, if vegetables or meat is past a certain number of days old and it is spoiled and it is non-obvious to the consumer, but it is no doubt likely to make them sick, not certain to make them sick, but likely to make them sick, then we are going to regulate that based on public health equities and a food safety standard, et cetera, et cetera, et cetera. And I think that it's important to identify what the concrete harms are to users when they act with incomplete information, regulate in circumstances where those harms are compelling, and give interested consumers, because again, consumers are not a monolith, right? They have a heterogeneous set of preferences and priorities. Some are deeply interested in privacy and security. Some care not a whit about it. And where it is best left to let those individual users self-sort based on their preferences, their priorities, and what choices they want to make. The idea that there is going to be a perfectly informed consumer making perfectly rational economic choices in any of these spaces is not true. And I think when you look at regulation, there are some circumstances where one can look at a baseline privacy law and say, look, a baseline privacy law needs to be very clear that certain practices that cause clear harm to consumers are outside the bounds of lawful activity. There are other activities in which some consumers like the practices, some don't. Those should be subject to some kind of choice, opt-in, opt-out, forced choice, et cetera. And so it's not a one-size-fits-all answer from my perspective.
Right. And Gabriella, do you feel like there are some of these value questions on which we do have enough convergence that, as John described, we could have regulatory intervention to say, well, people may have different tolerances for anonymity and privacy, but everyone wants at least this. Do we have a baseline?
You know, I think we do, or we can. Insofar as, again, I think people have already pointed to the fact that, let's just say, when it comes to data and platforms, consumers do and can benefit from the collection of data, but you just want to draw certain lines that align with the Fourth Amendment, for example, right? And so having that location data be used by the government for the purposes of, you know, maybe immigration and targeting certain families who have other members of families who are here illegally. You see what I'm saying?
Yeah.
Like there's certain lines that I think we can draw in the process and then have some flexibility as well when it comes to platforms and data. And what's so great about the present moment, I think, compared to about like 5 years ago, is there's a very public conversation about it, right? Both in civil society, in journalistic circles, and in policy circles, so that's wonderful. I think like shifting to a slightly different technology, something like facial recognition software, right, that is being rolled out in different cities, I think that's a different kind of beast and game insofar as, you know, all evidence points to the fact that the software is incredibly problematic. It misidentifies people, it targets vulnerable populations, and in that case, I support something like moratoriums, absolute moratoriums at the moment until we figure out whether a balance can be struck. I'm a little bit skeptical, but if we roll out the technology and it becomes part of the infrastructure, it becomes much harder to roll it back. So it's one instance where I think a very proactive response that kind of prevents it being included in city infrastructures is something that we should now be really thinking about and put that on the table and make that as much part of the public conversation as the conversation we have around data and platforms.
Interesting. Yeah. So it has certainly been argued, and convincingly so, I think, in many instances, that where technology is disproportionately impacting certain populations or has known issues, that we can pull back and we can sort through those before sort of subjecting it. On the other hand, right, the pushback has been, well, we don't know about these problems until we've rolled these things haphazardly out and then realized, well, it's misidentifying people, let's fix it. Baron, how, if at all, can we balance that, the need to have the technology out there wrecking mayhem before we know that it's going to be wrecking mayhem, and rein it back in? Like, how do we minimize the damage while we are giving it its trial run here on our lives?
Well, I agree with everything John said. I think that is exactly the right framework through which to look at this. And ultimately, the question should be how we adjudicate the facts. How do we know whether something is harmful, or what are the benefits? And it's going to vary case by case. But I think it is important to start from that recognition that, as Thomas Sowell once said, there are no solutions, only trade-offs. I really, really cringe when we get into conversations like, okay, so now what are the solutions? So these problems, I mean, it's true in two senses. One, these problems will never be, quote, solved, unquote. There is no end state where we will just decide that it's done and we can move on.
In the sense that new problems will
The same,
present?
and that the same problem will continue to recur in new ways, in ways that we don't understand yet, right? And then second, that these trade-offs are unavoidable. So my general preference is that we deal with these things on a case-by-case basis under standards. Now, there are times when we know in advance, when it's pretty clear that something is harmful and we can rule it out of bounds, or we can say, on the other hand, that something is should be lawful, period, going forward. But as a general matter, we don't necessarily have the information we need to make those decisions, and we'll only know if we allow things to happen in the marketplace and respond to them. So on a very high level, the Federal Trade Commission has been doing this for decades. Right? This is what unfairness and deception as a kind of unfairness are all about. And if you go back and read the unfairness policy statement, you see very beautiful, I think very thoughtfully crafted recognition that Congress understood that it was not possible to create a list of the specific bad practices that could be enshrined in legislation once and for all. And that's why we have Section 5 of the FTC Act. And I think going forward, my preference for dealing with privacy is that we build on that approach. And that may mean that we update, for example, the concept of deception to talk about trust and consumer expectations. That's an expansion of the concept of deception. Or that we talk about particular kinds of harm that may not be cognizable under the FTC's unfairness test. But that, in general, should be our approach. And let me just quickly say, one, on the question of states, I don't think that states should be in the business of regulating the internet. The internet is an inherently interstate and indeed inherently global medium for which we need, at a minimum, a consistent federal approach and ideally interoperable international mechanisms so that the internet continues to work. And by the same token, the questions that I think matter most in these debates are not necessarily about legal standards. Everyone gets very focused on what exactly should the law prescribe, or what should the standard be, and those things matter. But far too little attention is paid to the institutional design questions of when do we have rulemaking, when do we have standards, what is the right kind of penalty. And I think that the genius of the American system, what has allowed internet technologies to develop, for better and for worse, in the United States thus far, is that we don't have a system where if you fail to predict where the line will be drawn on an unclear standard, that you can lose your home, you can go to jail, your company can be put out of business overnight as a general matter. Those are the things that I'm most concerned about getting right, so that we build into the system some flexibility and tolerance for a certain degree of risk and a recognition that we don't know what the trade-offs will look like in the future.
Great. I want to come back to the question of states versus federal versus an international perspective. I'll give Gabriella a chance to follow up there, and then I'll pose that to the panel.
I think I just had a more philosophical question for Barron, which is, I mean, I recognize that it's a very difficult set of interventions and solutions, but it still strikes me as solutions. You know, you're moving forward, you're enacting laws, you know, they may or may not have flexibility, but they are solutions.
Well, I would call them responses, and they're ways of addressing problems on the margin. But these problems, very few problems are amenable to actually being solved, as in the problem goes away, right? These problems, again, will recur in different forms. And even in cases where there is some apparent solution, the trade-offs are still unavoidable. And we really, again, this is my point about cognitive biases earlier, we really want psychologically for there to be black and white and solutions to problems and to be able to move on. But what we need to do is recognize, the reason, you know, this is Madison's point about our Constitution, we build our institutions because we recognize human frailties. We need institutions that will be able to, over time, not fall prey to those really inherent cognitive biases in our decision making.
And I think one of the big challenges with solving problems and coming up with solutions is not just the evolving and changing nature of the problems themselves, but also the evolving and changing nature of our tolerances for certain things or our preferences for certain things, sort of our cultural and societal norms and what we think we do and don't want. I think those things can evolve. And so Barron has raised a couple of times the trade-offs between a rule-based system, something that's focused more on standards. I want to take that and expand it a bit. When we kicked off the top of the panel, Liesl started by saying that it really would benefit at least the privacy portion of this value divergence discussion if rather than having piecemeal states coming up with things, and it sounds like other people in the panel would say, well, that's okay also in addition to some federal protection. I want to talk about how important a cross-border, a global solution to this is in terms of the way in which we're going to interconnect with other people and the way in which our businesses and our commerce is going to work, but also to ask, without, really solving it, like how reasonable is this, given where the EU is right now, given where we are right now? Are we going, is it reasonable to say that we're going to agree on at least some baseline level, as we even amongst ourselves domestically would need to come to an agreement to? And if so, in broad strokes, what might that look like? And I'll start with Liesl and pose that to anyone who wants to jump in.
Sure. As I said before, I think a federal baseline privacy law is a good first step of kind of convincing our allies and our trading partners that we have some baseline protections in place and maybe don't need to negotiate an agreement with every different country with whom we want to exchange data. In an ideal world, perhaps we would create a secretariat and create an international legal instrument, maybe something like Convention 108 in a slightly modified form, in which we're all members and there is a kind of accountability structure. And if you are a party to the convention, you can exchange data with all of the other parties. That is probably not a realistic and certainly not a short-term goal, and it's possible that in regions like the Asia-Pacific region, that is simply not a solution that they would accede to. So, in the meantime, kind of building up those mechanisms for interoperability, looking at things like the Global Privacy Enforcement Network and ensuring that data protection and enforcement authorities can share data so that the cross-border cases can be investigated and there is accountability, and all governments know and consumers know that there is accountability when personal data crosses borders. That's a good first step to start with.
Great. Now, Chris, you mentioned that you're amenable to more local, regional governance of this sort of thing. How much of that do you feel, I'd like to hear more about sort of why you hold that view, and how much of that do you feel is effective in this, if we are ultimately going to end up with some federal regime that trumps it, and how much of it might just be performative to show that we in this community value this sort of thing, and here are some standards we would like the feds to consider when they're setting up their, sort of what California's doing. Like,
right,
how much is it the standards that are here?
Right, so the California privacy law is a great example of California taking action when the federal government wouldn't. Extremely important.
Yes.
We talked in the first panel, or at least I was talking in the first panel about the demand for accountability, the sense of urgency from technology users for a societal solution that people can trust and that people can take stock in, so they don't have to think about protecting themselves all the time with new uses of technology. So good for California for taking action, where the federal government is, looks like it's going to take at least another year or two to take action. Good for Europe for taking action. You can quibble with the details of the law, but
and I will.
Yeah, but I do stand for public servants stepping up to protect their citizens, and when we can get quality regulations at the state level that set the example for the rest of the nation, I'm going to support that. It doesn't mean I don't agree with Barron's point about the structure of the internet being global, and certainly the effectiveness of federal regulation. And I think that's why we're all actively working for a federal law that's strong and effective. But when it comes to the trade-offs, and I agree there are trade-offs. We have to be very specific about what harms we're trying to deal with. Privacy and control of one's own data is a very specific harm. There are others out there that are harder and have different trade-offs. We've talked a bit about content moderation. We've talked a bit about disinformation. We've had some conversation about illegal content. And how to deal with illegal actions online. All of those run up against the harm of censorship.
Yeah.
And promoting free expression. And so if we don't have an authority, I think at the federal level, that is expert in these specific types of technology, that has a higher standard than just what is good for the marketplace, what raises and lowers costs to consumers, but actually values things that we've talked about for a long time as being important values. Access for everyone to technology, diversity of voices and localism, the importance of public safety, and promoting choices for those consumers so that they can, when it's not a fundamental value like public safety or privacy, that they can still choose, a better content moderator over here than a different content moderator over there. I think it takes an expert agency to lift up those values and balance them and look at the trade-offs that Barron's talking about.
Right. I want to get back to a more in-depth discussion about content moderation, accountability, 230 momentarily. I'm going to let John jump in. I will just say I think some argument could be made. We can debate whether or not state governments are any more nimble than the federal government, but some argument could be made that in some cases states can move a little more swiftly or a little more expertly or tailored because they are maybe they have a particular industry in which they have more experience than other regions, and so it makes sense maybe for a large, heavily populated state like California to take the lead on protecting its citizens. John?
I agree that a baseline federal law that is interoperable with global regimes is the preferred path. I think it is a plausible one as a practical matter. I think it's something we can get to within the next year or so. I would pose a caveat to Barron's point about state regulation and local regulation, which is that I think there are some issues on which it's wholly appropriate for states and localities to regulate when it comes to data. To take a few examples, when a city government decides that the government will decline to install facial recognition technology within its borders, that is surely within the ambit of the city council, whether or not that data transits the internet at some point. When a state legislature decides that it will require state police to obtain a warrant before it engages in drone surveillance, even though the Fourth Amendment and the Supreme Court law in this area would not require such a warrant, typically speaking, I think that's wholly appropriate for a state to make that decision. When a state decides that public schools within the state will not contract with technology vendors unless those vendors meet certain minimum security standards for protecting student data, yes, that impacts the internet, and yes, the internet is a international and cross-border entity, but I do think that there are issues of local and state concern that might be appropriately addressed by these sorts of regulations.
Of course, I wasn't talking about any of those things. I was talking about state governments crafting rules for how private services are delivered to consumers. Okay, and let me draw a critical distinction here between crafting rules versus enforcement. I would absolutely agree that, of course, the state AGs should have a role in enforcement, just as they do now, just as they would have under the Obama administration approach. The question is, should state governments be writing their own rules to regulate the provision of internet services by private companies to consumers? That is often referred to as a patchwork. That image is exactly misleading, because obviously a patchwork is about each state having its own rules that apply only within that state, and obviously the whole point here is that these rules would effectively apply to the provision of services to all Americans. So there's a second trap that we fall into here, where some people might think, well, we don't have an international system that works perfectly, so and yet the internet works fine. So what's the big deal if we don't have a federal law and we just have states doing this? Well, this misses the two critical points. One, that we're talking at a minimum about services, especially being provided by smaller companies, where the market they're targeting is the United States. They want to provide service to all Americans. And second, as every lawyer in the room knows, international shoe means that you have minimum contacts with some state and you can be sued there. And the Patel decision by the Ninth Circuit recently, which the Supreme Court recently declined to rehear, declined to grant cert regarding, means that if you violate in some fairly technical way some privacy law of a state, you can be hauled into federal court and sued under that state law, right? This fundamentally is why we cannot have a so-called patchwork of states trying to regulate internet services, because every state will regulate every service provided to every American. We need a consistent federal standard for doing that. And I think the Obama 2015 approach, which I failed to appreciate at the time, I think was actually a pretty good framework for how to deal with this problem. And I think a lot of us would be quite happy with that as a starting point. Not that there aren't things that we haven't learned since.
Yeah. To stick with the thought of platforms, specifically services they're providing to consumers, I want to move to one of the topics that we listed as one of the big issues of conflict here, both locally, globally, and short-term, long-term, that is accountability. If we're talking about a potential need to move to some global consensus around how these things are going to work, which it sounds like would be the natural extension of Barron's argument, states can't do it because they'll impact all other Americans, and certainly America can't be the only ones doing it because the interwebs are everywhere and we would be impacting other people. Perhaps you would say, well, yes, because as Barron noted, everyone wants to sell their services to us, and so maybe we should take the lead and we should use our federal privacy regulations performatively, right, as a signal as to like what we value. The challenge being, just taking 230 as an example, and the debate that's surrounding it, what do we value? What do we think about accountability, right? It's easy to say, yes, let's show the world how it should be done. How should content moderation be done? I'll throw that to the panel. Chris, do you want to kick us off?
Sure.
Let's see your sly grin.
It's 2:30 is such a fun conversation. I think there are aspects of content moderation that we have to hold up as critically important for society. So I start with easy scenarios like the debate over advertising online. We've had decades of rules around political advertising for television and radio. Why we don't have rules, or why no one's, very few of us are calling for rules around political advertising online. I hope more folks will join us in calling for Congress to take action on that, because these are the sort of content that impacts just the foundations of society. But moving beyond things like that are much trickier, I'm wary of government oversight of content, and so it leaves us with a difficult trade-off. The trade-off of how do you empower platforms to monitor and moderate content. 230 does that. It's the intention of the law. And how do you ensure that harms that come with moderation at that level, where you have to pick someone to be in charge of making a decision, and if it's not the government, the next choice is the platform, or just no moderation at all. I would rather have the platform choose. The counterbalance trade-off is that you have to have choices in the marketplace where people can go and move away from harmful situations. So if if Facebook is going to moderate more stringently than 4chan, then great. I don't want my kids on 4chan. And I want to have the tools to be able to help them, steer towards more, kid-friendly and quite frankly, civilized conversation.
Right.
But if we don't have pro-competition rules, then we can't get there on content moderation.
Okay.
And so, this is why I keep coming back to having an authority that actually promotes competition among platforms in the marketplace.
I want to leave plenty of time for Q&A, so I'll let let Gabriella kick in, and then we'll start to bring you all into the fold. So please get your great questions ready. Gabriela, are these all or nothing solutions? How do we accommodate? So Chris said, I favor if I have to pick the platforms doing it. Well, what if I say I favor no one doing it? And what if Barron says, well, I favor the government doing it? So how do we make the decisions between these heterogeneous and endogenous preferences when it comes to stuff like this?
I mean, I think given the fact that currently there are many different types of platforms, and we thankfully don't have a monoculture, and I'm also very much against monocultures online, and feel that we have to kind of have spaces for very different types of communities, and there's various kind of economic and societal mechanisms to incentivize that. We're going to have, at some level, with some elements around content moderation, there's not going to be one solution, right? Some of the solutions are going to be based on the differences between platforms. I think the important part, nevertheless, is that there is a public conversation at certain moments when certain forms of content moderation are not working. So, 5, 6, 7 years ago, when Danielle Citron was pointing out the problem of massive harassment and trolling against women online, an initial response was, well, there's not much we can do, right? But there was at least some good enough solutions in order to, not fully solve the problem, because as Barron noted, they're never going to be fully solved, right? But get us to a better place.
Interim mitigation measures.
Exactly. And I think we just have to keep participating in that process. And I think one of the tough parts, and this is where I'll finish, is if you compare a highway system to the internet, the highway doesn't change much, right? There's potholes, there's tolls, but it's relatively stable. The ecosystem of the internet is highly dynamic, right? Maybe 4chan won't be here in 10 years, right? And so we're going to always have to be constantly revisiting some of these questions, depending on the new types of affordances that get built into these platforms will enable new and different forms of socialities, and we'll have to constantly be revisiting the question.
Great, thank you. I'd like to turn now to bring in your questions. As per the traditional Silicon Flatirons tradition, we'd love to start with a student. So if you are a current student and you have a question and would be willing to kick off our audience Q&A, please raise your hand high so that we can see you. Okay, right here. Alan.
Hi, everyone. Thanks so much for being here today. My question for you is, what role does and should technology play in the decisions that you're actually making and the decisions that you've discussed? I guess what I'm saying by that is right now we're in a big room with a bunch of people, and you're all having a very intriguing conversation at a wooden table detached from a lot of screens and devices. But when you actually have to make these policies, is that the same sort of format we want to use? People in a room, sort of not. What are we relying on? Are we relying on any automations, polls, data in making these decisions? How does technology influence our decisions about technology policy?
John?
So I'll just take it quickly in a very basic way. Much of the work of the Federal Trade Commission is driven by technology-enabled reporting of deceptive or unfair trade practices. The FTC publishes a report every year of the top categories of complaints they've received from consumers. It opens investigations regarding those complaints. You also, I think, can look at some recent circumstances involving whistleblowers that were aided by technology, aided by the ability to speak confidentially and secretly with regulators and with others about the details of business practices that they believe to be either illegal or unsafe. So I think, yes, there should be a data-driven approach to what the priorities are for enforcement entities. There should also be technological mechanisms to try to aid in the communication of important information, particularly in high leverage situations where employees or others are at some risk of retaliation.
Thank you. Professor Kaminsky?
So So I promise this is a genuine question because I struggle with it. When you look at states' roles in privacy regulation, the historic role has been largely around the process of privacy torts. And those torts, again, to reference the wonderful Danielle Citron, have largely been maladapted for application to the internet. But there's no reason to think post, say, the Supreme Court decision in Carpenter and other Supreme Court decisions in the Fourth Amendment context around data privacy harms that the application of the privacy torts might not then be adapted for application to the internet, given changes in understanding of what privacy in public looks like, giving changes in understanding about what sharing information with third parties does to your expectation of privacy. And so to put this in the form of a question, I really struggle with ridding states entirely of their historic role in privacy regulation, given that these torts that have been built around harms to local constituents that are situated in local environments have historically been handled by the states. So basically, what do you do with that when you talk about preemption? What do you do with the fact that states have been the primary regulators when you talk about situated privacy harms, which really do connect to a lot of things we now consider to be data privacy harms, like IoT surveillance, drone surveillance, fill in the blank?
Barron, I'll let you start.
Yeah, well, again, I think preemption is all too often framed as saying the states have no role, and that's not what I mean. I think I was pretty clear about saying that the states, and specifically state AGs, have a role to continue to apply their existing baby FTC acts, also to apply and enforce the provisions of federal law. I'm quite open to that. What I object to is the policy question of which are the privacy harms that should be remedied and how should they be remedied and what penalties are appropriate being decided by state legislatures. I think that question is one that should be decided by the Congress, and the states should be given an enforcement role, and private parties should be able to have certain rights, whatever the balance of rights is decided in the private rights of action, to sue as necessary in state courts, because these are not always going to be large international platforms. There are, of course, if we're talking about a comprehensive privacy law, you're, of course, going to have cases where you need to bring some kind of small claims suit against your dry cleaner for failing to protect your information. And of course, the proper remedy for that is not going to the FTC or even to your state AG. You may want to have a private right of action that you can bring in state court. So I think that is a role for, let's say, state mechanisms rather than for states, which I think usually people mean state legislatures, to resolve some of these privacy disputes.
Okay. Yes, right here. In the front here.
Thank you. So a question about accountability, that's been a key topic in solutions as well. And the real question is kind of where will the solutions come from? A lot of the basis in the conversation here was about federally based solutions. But if you think about like privacy and think about the context of where we've come on that journey, I'm old enough to remember when we used to think about, we had a US approach, a Chinese approach, European approach, and that quickly has melded more. The last two have kind of melded a little bit more together. And the incumbency factor for companies that have complied with GDPR has led to like a lot of, well, we're already doing this, why not do this? And so when we think about a platform accountability, looking at where the EU is going as it relates to that being a critical element of the next commission, thinking through kind of how they've started with their platform to business regulations. California adopted something similar to that last year. Looking at how they're going to redo their e-commerce directive, to think about questions around liability, product liability, IP rights for platforms and others in that space. As that moves along, are we going to be in a position 2 to 3 years where some of that's going to take place? We're still going to have inactivity in the federal level where we're going to be, again, responding to that activity from their framing? Do you think there's an opportunity? Do you think that we're going to get there or not, I guess is the question in terms of our end? Are we going to be leading or responding?
Lisa, what do you think? I mean, at this stage, I feel like we're responding. And, in the federal privacy debate, I do see potential in the next year or so for a law in that regard. But with regard to all of the other issues, the stakeholders seem to be far apart still, and we need to come together and we need to talk about the solutions, or else we will continue to be responding to standards that other geographies set.
Great. Right here, and then right here.
Hi, I'm Greg McLaughlin with Charter Communications. Not a lawyer, an engineer. And first of all, I'd blame all this on the marketers and the psychologists and not on the engineers. So just in our defense, because they're the ones that are, monetizing it. But my question is, it's kind of a false choice. In that it's not a question in my mind of whether or not we can have privacy or no privacy and the internet will remain the same. If we were to completely lock down at extremes, the ability to sell ads, ability to collect any sort of data, location, whatever, how many of these services that are out there would just disappear and the entire utility of the internet would be different? And so I'm interested in opinions on that.
That's a really good point. Yeah.
Can I jump
ahead,
in?
please.
It's not going to disappear. It's part of the infrastructure, right? The hardware, the software, the expectations, right? Like
But architectural design choices are architectural
Right.
design choices, which will influence the utility and
Right.
the way in which we use
and
these
they will continue. They will continue. And so I actually think, given the fact that there is just too much data leakage, collection, there are huge potential harms. I mean, the hard part is to, bake in some legal, technical protections, right? But I think moving forward, given the fact that there are multi-million, billion-dollar companies that are in existence, collecting this data, providing these services, part of everyday life, they're not going to go away. So we don't have to worry about that part. We just have to worry about being able to either push those companies to reduce the data harms and or create different types of technologies, whether it's Tor or Signal or Brave, that provide kind of different, more privacy-focused ecosystem, which will always be the underdog because it's hard to make money off those technologies as well.
So Gabriella said a moment ago, it's not going to go away. It's going to be there. The internet's going to be there. And it just became pretty clear that what she primarily was talking about is those big companies. But that's not the entirety of what we're concerned with, and it may not even be primarily what we're concerned with. So take, for example, what's happened over the last year regarding children's privacy. So just very briefly, the FTC settled a case last year that for the first time started to hold responsible the individual developers of videos on YouTube. And all of a sudden, for the first time, these people who are literally mom and pop shops who put up great videos for kids or for teenagers, or we had a lady who just does content creator content, right? And she does a lot of things that are for adults. She thinks her audience is adults, but she's afraid that the FTC might ultimately decide that her content is child-directed, and therefore that it should go into the child-directed category, which means that all of the functionality on YouTube for that content will be crippled. So it's the ability to subscribe to a channel, to post comments, to follow someone, to have any degree of interaction, and, oh, by the way, to have relevant advertising, which means that the revenue consequences here, when you roll all that together, could be that they lose something like 90% of their content. So if the it we're talking about is the long tail of people who create content like that, those people are absolutely terrified, and many of them are already going out of business, changing the nature of their content, deciding not to focus on teens because they're too concerned that may get them swept into this regime, and they're adding in vulgarity to their content to make it not child-friendly. So I'm not kidding, right? We are seeing a real-world example of this playing out, and the result was that almost 1 million people signed a petition urging the Federal Trade Commission to rethink its approach. These are the kinds of consequences that we're talking about here when we talk about something that is as mom and apple pie as children's privacy. That seems to be easy, but when you actually get into the real-world trade-offs, is really painfully difficult. And so I just implore you to, whenever you have this conversation, not to fall into generalizations like it or platforms or services. We really have to think carefully about who's going to be affected and what the disparate impacts are going to be.
So if I could just add, this is why, I mean, the difficulties of these trade-offs is why I think it's important that we have an authority that actually understands the differences of each of these types of platforms. Because if we just say platform, it's just too big. And YouTube is very specific. It's in the video marketplace. How does it interact with traditional video marketplace values that have traditionally been regulated at the FCC? And when is it like cable and satellite, and when is it not like cable and satellite? These are questions we haven't even wrestled with yet, but are coming, and we're going to have to wrestle with. But at the same time, we certainly heard yesterday that we can't excuse design of a platform or design of a business or a service, or even sometimes the choice of a business model, and say there are not ethics involved in how it's designed.
Sure.
I think that's one of the arguments around the lawsuits around Airbnb, where yes, they are protected from liability for third-party content from Section 230, but it does not mean that they have a right to build a business model that promotes and enables housing discrimination.
Absolutely.
And so let's draw some clear lines there, and to have an expert agency that can actually do that with each type of platform would be really helpful.
Let's. That's a perfect segue into our keynote conversation with FTC Commissioner Chopra, which is up next. So please, we'll get out of the way and allow them to set up, and that's what's coming up next. Thank you to all of the panelists here today.
Thank you to our panelists who did double duty. We're going to take just a brief moment to do a set change, but then we're going to jump right in.